everybody. It's 9 o'clock. It's me and Mr. Brian Drew. We're with you again to talk about what we expected really to be the Illinois Supreme Court ruling today. We'll go over a few things with you, but in starting, I want to read something to you that I think is interesting, and I think then Brian will have a few comments about that. So after this ruling come out today, you've got, and just so you guys are aware, I had to have a medical procedure. So I have a doctor's prescribed little bit of medication in me right now. So if I get colorful, I apologize.
I don't think it takes medication for you to get colorful.
It doesn't take medication, but it's going to make it extraordinary because I'm pissed off.
Yeah,
and rightfully so. To go. So anyway, so this little bum, Dan Caulkins, I'm just going to go right out at it. He's a bum. I have more disdain for him than I do Governor Pritzker, because at least Governor Pritzker would come right out and say, this is what I believe and I'm going to fight for. You got a bum grandstander like Caulkins who has probably harmed every law-abiding gun owner in this state. But he put a Facebook post out today, you guys. He put a Facebook post out. And I'm going to not read the whole crap, but I'm going to read the end to you, okay? We know that other state court challenges are proceeding. They're talking about us, okay? And we trust that our charge illuminates issues to improve their challenge to this unconstitutional legislation. We trust that our charge will improve their challenge. Now, Mr. Drew, I'd like you to opine on that because I think you'll do it better than I will.
Well, I mean, initially you were very clear. You said, hey, well, they took your complaint, copied it and pasted it, and then used it. And then you asked them, hey, wait, let's all go together. You guys can lead. You guys can be out front if you want. Let's all wait, go together. Let's get some facts. So that if we have facts about how people are similarly situated, because if you don't, you're going to be purely on a facial claim and you're going to have zero facts, zero evidence to show that you're similarly situated. And you run the risk of the Supreme Court throwing you out for that reason alone. That was exactly what you said. You asked them multiple times not to do that. They went forward with it, went ahead, and they lost on almost that exact grounds. I'm not happy they lost, and I know you're not happy they lost. But the frustrating part is that claim now becomes, well, it now puts the Supreme Court in the position where they could tell you and I, when it comes our time to head up there, we're not even going to take it. We've ruled on it. We don't care what you say. Now, we're going to try. I think you've got some great insight and some great ways to try to get around that. And we're going to fight like hell to do it. But it does place us in a position where the automatic going up doesn't happen. It's now in their discretion. And I don't like the idea of leaving that issue in the discretion of the Supreme Court of whether or not to hear it, because from the rulings they've made so far, they're not terribly inclined not to grant about anything the governor and the legislature wants at this point. So
exactly. And that was very professionally put. I'm going to color it up a little bit. How many times did we come on here, Brian and I, and tell all of you that this is exactly how Dan Caulkins is going to screw this case up? If he goes forward with no discovery, no facts, he's going to lose because the Supreme Court's going to say you can't meet your burden of proof that your clients are similarly situated to the exempt classes. Remember me saying that? I said it over and over and over. And guess what the Illinois Supreme Court said today? They said, Dan Caulkins, you lose because you didn't satisfy your burden of proof to show that you're similarly situated to the exempt class. No shit. Because you didn't do any discovery. You can't do it without discovery. And that's why when the governor, and again, I'm not criticizing the governor or the attorney general because I'd have done the same thing. When they came to us wanting us to run to the Supreme Court, I said, I don't think so, Scooter. It ain't going to happen because I know I'm going to lose. And so what they do, they're like, oh, okay, we'll go see Dan Caulkins, Super Dan. And they laughed all the way to the Supreme Court with that guy because they know they had him. Now, I'm going to assume that Dan Caulkins is just stupid. I'm not going to assume what other people assume is that he's crooked, because there's a lot of people saying it, and I'm not saying it. I'm just going to assume he's stupid. But whatever reason, he did everything that had to be done to lose this case. He did it perfectly. If you read the opinion of the Illinois Supreme Court, now keep in mind, this was a 4-3 decision. So there were 3 justices that didn't agree with they saying that this law is constitutional. They didn't for a couple of different reasons, but there were 3 of them. We only needed 4. Just think what we could have done if we would actually had a case. We would have done some work, which is what we have always wanted to do, because we knew that that's what had to be done to win this case. Okay? So that's what they said. They said that the law, they really reversed the decision of the Macon County judge that found the law was unconstitutional. They reversed it. And they said, if you read it, it's because Dan failed. I don't have it in front of me, but it said Dan failed to put his burden forth that they were similarly situated, which means how are you the same as the exempt categories? Because if you're the same as the exempt categories, then the law is unconstitutional. But you have to prove that, you guys. You can't just say it. You have to prove it. Because the presumption's in favor of the government. And they had nothing, had 0. And that's why the Supreme Court said that they lose. Now, there's a couple of things worth noting about this. Remember the issue, one of the bigger issues that I've told you all along that's bigger than this gun case. The procedural gamesmanship of how they pass these laws, the gut and replace, the 3 readings rule. 2 of the Supreme Court justices brought that issue up in their dissent and said they wanted that issue dealt with. But you know why they couldn't deal with it? Because Dan Caulkins didn't take it up on appeal. He waived it. They put in there, you failed to preserve that issue for us to hear because you didn't do it right. If he would have taken the 3 readings clause up, which I also begged them to do, we might have won, right, Brian? We might have won that issue.
Yeah, we had
2 judges for certain. Go ahead, Brian. Go ahead.
Yeah, we had 2 judges that were for it, and the majority, which the 4 of them, in their conclusion, and this is their quote: "Third, we hold plaintiff's failure to cross appeal from the denial of relief under count 2, that was the 3 readings rule, bars them from renewing their 3 readings claim here." Period. So they went, we're not even considering that. And 2 of the justices, Justice White and Justice Overstreet, hammered that and said, we don't even need to get into equal protection because this has been going on forever. The legislature violates the Constitution, and we as the Supreme Court have a paramount right and obligation to force people to abide by the Constitution. But they said, well, the majority said, well, it doesn't matter because he didn't bring that to us, so we can't review it.
All right. I'm going to read this. I'm going to read this because Cody just did a good job, Cody. He put the main part. We hold that the exemptions neither deny equal protection or constitute special legislation because plaintiffs have not sufficiently alleged that they are similarly situated to and treated differently from the exempt class. What that means right there in English, you didn't do any discovery. Then it says, second, plaintiffs expressly waived in the circuit court any independent claim that the restrictions impermissibly infringe on Second Amendment. True. Thirdly, plaintiffs failed to cross appeal is a jurisdictional bar to renewing their 3 readings claim. Guys, I can tell you what, I have met a lot of attorneys in my life, probably not many as Brian. I've never seen anybody give a perfect storm of bad lawyering than what I've seen right here. Nothing was done right. And it all was a result of rushing it way too fast, playing right into what the governor wanted, right into what the attorney general wanted. Okay? So we can't beat that horse anymore to death, other than I personally hope that Dan Caulkins moves out of the state of Illinois, and he ought to resign from the General Assembly tomorrow, in my humble opinion as a citizen of this state, because he's incompetent and he doesn't deserve to serve the people of the state of Illinois for another second. That's how bad it is, in my opinion. So the TRO that we have in this case is still in place. The only time that that TRO would go away is if the Supreme Court would have done something about it, which they didn't for a lot of reasons, or if, two, the judge in our case dissolves it or takes it back. That's not been done yet. I highly expect that the Attorney General's office is going to file something next week and ask that that be dissolved. We've got a few ideas of how to deal with that. I don't know if they're going to work, but I can tell you that it's coming. So there could be a chance in the near future that the TRO gets dissolved. Okay, I can't say yes, I can't say no. I can tell you that until a judge enters an order, that it's not gone. Okay. And so all of these Sunday lawyers out here talking about it, and there were even a few reporters, with all due respect, go, oh, the TRO's gone. It's like, how? It doesn't. You just wave a magic wand and make it go away. Some court has to dissolve it, and as of yet, no court has dissolved it. What likely they're also going to ask for is they're going to ask that our case be dismissed. That's what they've always wanted. They've always wanted our case dismissed because they know that we have the plan to take this case and take this law out, right? I can't tell you with 100% certainty we'd win, but I can tell you if Dan and his shitty case got a 4-3 decision, we only need one more justice to swing our way. And I tell you what, I think we could have got him to swing our way when we would have done what we're doing. Let me give you an example. Who is similarly situated, right? The exempt category and the citizens, you of the state. How are you similarly situated? Because if you can show you're like them, then they can't carve you out. Let's talk about, and I've told you this before, let's talk about prison wardens. Brian, go ahead and read that part that you were reading to me about the law enforcement, the prison wardens. Listen to this, you guys.
Oh, yeah. So they were going through talking about all the training law enforcement has because they have those 7 exemptions, and they were going through them all. And they're talking about all the law enforcement agencies, officers, and then they also talk about armed services, National Guard, and then they come to this exemption with them. And it says, finally, the exemption applies to wardens, superintendents, and keepers of prisons, penitentiaries, and jails. That's it. Don't explain how they're trained, doesn't explain how they should be exempted out, doesn't say anything about them, just glosses right on over that. And the reason they gloss over it, in our opinion, is clear. There was nothing in the record or evidence to show that they weren't trained, and there's nothing in the record that they are to be trained other than the governor and the attorney general said, oh, well, they're trained. And so the Supreme Court just assumed that they are because there was absolutely no other facts presented to them, which is the frustrating part again of why you don't rush this thing up there without the discovery, because that I think that's the Supreme Court recognizing that's an issue. But fortunately for them, Caulkins didn't, and his counsel didn't present any evidence at all on that. And it wouldn't have been, we even tried to get them to put some affidavits together, do something. We tried to help them, which is even more frustrating, but because we want this to win for all the people of Illinois. And that's the frustrating part.
Exactly. And well said, Brian, because they glossed over, they were always going to give the governor the benefit of the doubt, right? Always going to give him the benefit of the doubt. So when they're in there saying, oh, they're trained, are they? No, because of the 27 prison wardens that are existing in this state, only 12 of them have any training whatsoever with a weapon. 15 people who are prison wardens in this state have no firearms training of record. So if they're just a prison warden with a FOID card with no firearms training, are they similarly situated to you as a citizen with a FOID card? You're damn right. You're in the exact same spot. Guess what? If those facts are in front of the Supreme Court, we might likely have won, because you are similarly situated to some of the exempt classes. You don't have to be similarly situated to all of them. You don't have to be the same as a Navy SEAL or a sniper for the Cook County, task force. You just have to find people within their exempt categories that you're just like them. Guess what? There's a bunch of prison wardens. You're just like them. But no, they were too lazy to do that work to put that in place and show the court that you were similarly situated. So if we get the chance, if we can survive this disaster of Caulkins, we're going to try to build the case that puts this back in front of the Supreme Court and lays it all out. The reality that you have to understand and appreciate, they've now ruled in favor of the state on this gun case issue. And you're going to have to recognize we're going to try to go back there in less than 6 months and say you were wrong before. We're not going to really say you're wrong. We're going to say you didn't have a complete record, right? So here's better facts for you, and you need to revisit this. But it's a tall order to go back and try to take a second swing at the apple, because that crap that Dan Caulkins wrote on his Facebook, maybe we illuminated the way for you. You didn't illuminate shit, because what happened is what we told you was going to happen, and all you've done is cause problems for us. You didn't illuminate anything. It's just ridiculous they would even say that. It's a slap in the face. So,
and you know, Tom, the information about the level of training or lack of training for the wardens of the prisons, where did we get that from? A subpoena, discovery, which, you know, I mean, I know we're harping on it, hammering on it, but that's what's so frustrating. It wasn't even like it was hard to find. I mean, you sent the subpoena out specifically asking for those things because we knew we needed it, and we got it back. I mean, it wouldn't have taken them. It didn't take us very long to get that. And that's what's, you know, intentionally frustrating about the whole thing. But, and now, did you, you know, we could talk a little bit about, you know, one of the angles, which was the Supreme Court Democrat elected.
Yeah, you want to talk about that? Yeah, Justice O'Brien,
he dissented.
Democrat, wrote that dissent that Justice O'Brien wrote was one of the best dissents I've read in a long time. And you pull it up, Brian?
Yeah, I got it right here.
What he says in a nutshell, you guys, is because here's one of the things where the Supreme Court, again, always going to give Governor Pritzker the benefit of the doubt. Just live with it. Is when you're dealing with equal protection, you have to say first, what is the legislative purpose of this law? You have to, that's a two-step process. What's the legislative purpose? And then you can look at the people, the citizens like us, and then the exempt categories to say, are we similarly situated? You can't do that unless you know the legislative purpose. Guess what? There's no legislative purpose written anywhere in the record of the legislature because they gut and replace this thing in 2 damn days. But the court, and it's, I don't know, it almost like it pulled a rabbit out of the hat, said that reducing the amount of these types of weapons off the street is the legislative purpose. I disagree with them, but let's take what they said for face value, that getting the guns off the street is the purpose of the law. Then they say, okay, these exempt categories are different than the citizens because they're well trained. And Justice O'Brien very eloquently said, what the hell does training have to do with getting guns off the street? It doesn't make any sense. It's irrational. And you know what? The majority opinion doesn't even touch on that. They don't even try to reconcile that their legislative purpose and their categorization of training, they don't make any sense. And that's how I saw it, Brian. Go ahead.
Oh, no, that's exactly what it is. And because the classifications, these people they've exempted out who get to keep these type of weapons where everyone else can't, has to be related to the purpose of the actual statute. And you're exactly right. The Supreme Court made up a reason, and that was to reduce the number of assault weapons in circulation because they are often used in mass shootings. Now, O'Brien's dissent says, I'm not going to argue. We're not going to get into that, although he cites that it's actually not the case. But he says that doesn't even matter, even though that's not true. But he clearly says the classifications have to further the legislative purpose of reducing the number of assault weapons. I find that they do not and will not reasonably remedy the evils the legislation was designed to combat. He says, look, 60% of the weapons used in crimes in Illinois come from out of the state. You did no one from outside of the state has to stop manufacturing them. No one's prohibited from driving through the state with them. Technically it would be illegal to bring one in the state if you're an Illinois resident. But like he said, 60% of the weapons come from outside the state. Nothing in this legislation is going to stop it. And the worst part is the governor and the legislature got together because they want to make it look like they're doing something. They want to make it look like they're making people safer. And the worst part is they're telling people you're going to be safer because of this, when in actuality, it was all fake. They're not going to stop anything here. This doesn't stop anything. They took away people's constitutional rights so that they could look good on the net. And I think particularly because J.B. Pritzker wants to look good and be good on the national stage because he has this pipe dream that he might get to run for president. And if he can do this, he'll be the liberal dream because he stopped guns when he hasn't stopped a damn thing. And he can't stop anything here in the state of Illinois. And it's just, it's just the reasoning behind it. And Justice O'Brien's clear. I mean, it just doesn't relate to it. And he told him straight out. So that's, fortunately for us, I think that might get a foot in the door to get us back in there when we have the actual evidence to show that even if we want to go with the majority's statements that, oh, these rationally related, which they aren't, that, several of these people aren't trained any more than you or I.
Right.
Actually, you're probably more trained than them. You've been through real training. So
I'm a certified firearm safety instructor for children in the state of Illinois. Is he still here? Yeah, look. I've got a card and a patch. I can teach children how to handle weapons. But that Barney Fife warden that doesn't have any training is more qualified than I am. Samuel makes a good point. He says, what reason would the court have to relitigate the case? They can just say it's already been decided. That's a possibility, Samuel. We're going to argue that there's still things to be resolved here, but I guarantee you, that's it's a good point you bring. They're going to argue this has already been decided. It's over. This case needs to go away. That's what the governor and the attorney general are going to argue. And we're going to have to argue that it's not for some of the reasons we've been talking about here. And somebody down there said, well, we're talking about this online. Are they going to see it? These attorneys aren't stupid, you guys. They know exactly what Brian's thinking. They know exactly what I'm thinking. They know I know what they're thinking. There's no secrets when you're dealing with this stuff at this level, unless you're the attorney general's lawyers dealing with Caulkins as his lawyer, because they just bamboozled them. One of the things I wanted to correct, and I don't know if I'd ever told you that actually, Brian, but those records that we have on the prison wardens, we never got the return from a subpoena.
They denied that again?
Because they never answered our subpoena. We got them because Kirk Allen from the Edgar County Watchdogs actually FOIA'd them.
Okay.
And Kirk got an answer to the FOIA, and that information then he forwarded on and sent it to me. So as of yet, they still haven't answered any of our discovery because they got the court successfully to just say, we're going to wait and see what happens before that proceeded. So yeah, that came from a FOIA from Kirk. It didn't come from our subpoena. I don't think I ever told you that.
That's all right. No, but in all honesty, though, when you look at this, it's why they wanted this never to see the inside of a courtroom, because they know they violated the 3 readings rule, and it violates the Constitution. And very importantly, and we haven't touched on this, the Overstreet dissent that he concurred in, they very specifically talk about that. And the big thing you and I have talked about all along, that the Speaker of the House and the President of the Senate have these obligations to uphold the Constitution, and they've taken an oath to do that, and clearly violated that oath. And they said, look, as the Supreme Court, we have an obligation to stop this. And specifically, they actually cited Judge Vaughn's in our case, the accuracy firearms case in the 5th District, cited him and said, allowing lawmakers to continue to ignore constitutional mandates under the Enrolled Bill Doctrine, knowing full well the constitutional requirements were not met, belittles the language of the oaths, ignores the need for transparency in government, and underlines the language of this state's Constitution. I mean, you can't say it any better than Judge Vaughn said it in the appellate court in our case.
Nope.
And that's the frustrating part, because we have that issue. We're taking that issue all the way up, and to just ignore it is frustrating. But yeah. I guess procedurally, though, we probably should tell people, I mean, expect next week we're going to get our motions to dismiss, a motion to dissolve the TRO based on the Supreme Court's recent ruling. That'll come. I would imagine they're working on it this weekend to get it to us next week. I can't imagine they're going to wait long to get it to us.
Nope, I agree. And, that stuff could happen. We told you guys that all along. Our worst case scenario could be that this all disintegrates. And when that happens, I hope all of you call Mr. Caulkins and tell him how pleased you are. Because it's 100%, not 99.9, 100% his doings. He copy and pasted your lawsuit. He didn't do anything. He copied and pasted it verbatim. filed it in Macon County, got a ruling out of Macon County, not because of any work that they did, because they had to follow the accuracy firearms ruling. Didn't do any work, no discovery, no effort to build a record, to build a case, to show the Supreme Court of Illinois, you cannot agree with the governor under any set of facts because these reasons why. He didn't do any of that. He ran up there with no record, with conjecture and bullshit, and the Supreme Court ruled against him because he couldn't satisfy his burden of proof. It was on Dan. It was his burden to prove the things that he needed to prove, and he couldn't prove them because he didn't do any work. That's the truth, right? So while I'm disappointed in the Supreme Court's opinion, and I think they made some errors in their reasoning, I understand in part why they did what they did, because Dan didn't have any facts. Not one damn fact. And I begged and pleaded with them. I said, you want to be the glory child? Step out front and we'll all run this case together. You want to be big boy? I don't care. I never cared about that. Oh, no. We're going to run to the Supreme Court now. We're going to fight for you. It's like, no. And every law-abiding gun owner or citizen in this state just got screwed over because of Dan. And I'm pissed off about it. And I'm going to do it. Brian and I are going to do everything we can to try to preserve what left we have of this fight in the state court. Because keep in mind, we still got the federal case, you know, the cases that are going on. So that's still separate. But in the state court cases, we're going to do everything in our power to keep these issues alive and try to get back in front of the Supreme Court with a real case. Can we do it, guys? I don't know if we can do it or not. We're going to try if we can. But if we're not successful, I wanted you to know why. And sorry, that's my colorful version, Brian. Go ahead.
I don't know. And you know, the thing is what we talked about all along early on. The reason the discovery is so important is precisely what they talk about in the dissent. That, you know, these lawmakers take an oath of office to support the Constitution. And when the Speaker of the House and the President of the Senate affix their name to this, they're taking an oath that says we have followed the Constitution. And we were going to put them in a deposition, sit them down and say, you knew it, didn't you? And put them under oath. And they haven't answered our complaint. They're fighting like hell to not answer our complaint, to not answer our discovery, and to never get in a deposition, because they know if they do, they lied one time or the other, and they're going to have to pick which time it is. Either it was when they certified it, and it's clear. I don't think they can say anything else. And the bad thing is now, with what the procedure we're in, had we all waited, we'd have got to do that discovery, and we'd have guaranteed got that. But, you know, the hopefulness is that we can, because we're going to work very hard at it. We're going to get after it. But I think we're going to do everything we can to keep this going. And I think we have a couple unique legal arguments and issues that I think should carry us on to the Supreme Court again because of a different type of claim that we're now going to make in the matter in which we're making it. So we're still going to try and fight to get there. But it's
hold on a second. I don't know who this bum over here is. We're paying you for this, and you aren't doing anything but watching everyone else's cases. I don't know if he's talking to us or not, but you call me back yourself, and we'll have a little talk about that. We're not watching everybody else's cases. Our case got set to the sideline because of the other case. We continued to try to push our case while their case was going to the Supreme Court, and the court said we couldn't proceed. So don't tell me we're sitting here waiting, not doing anything, watching everybody else's cases. The court put our case on the sideline. So don't run your gums over there. You don't know what you're talking about. So we got anything else? You think that covers it?
I think that's where we're at. And, you know, I guess as soon as they give us any pleadings and then once we get procedurally in a different spot, I guess you can come back and keep everybody apprised of where we are.
Yep.
But the TRO, our TRO is still in effect, just as a final clear thing. It's still in effect, correct? I mean, nothing's changed there. I haven't seen anything.
Yep. All right, guys. It's 9:30. Have a good night, and we'll be back when it's time, okay?